Hello, and thank you for joining us today for what should be a very interesting conversation about enduring powers of attorney. My name is Brett Osmond, and I am the editor of Compass. Compass is Australia's national information hub on elder abuse, and we have lots of interesting sections and topic areas. One of our most popular is on powers of attorney, and that's compass.info. I'm coming to you from Sydney on Gadigal land, and I'd like to pay my respects to elders past and present, and to welcome you all today for what should be a really interesting conversation with Anita Koochew from the Eastern Community Legal Centre in Melbourne. Thank you, Anita, for joining us today.
Thanks so much for having me.
Now, just a few little tidbits to get us going. We're going to be using the chat for questions. So please put your questions into the chat and Anita and I will answer those. I've got a few questions to kick us off because there'll be many people joining us today who are either thinking about an enduring power of attorney, have one, or have encountered some issues or have some questions. So today is a really great opportunity to get your questions out and for us to go through them with you. We'll be sending out an email tomorrow with a recording of today's conversation, along with links to the You Decide Who Decides guide. We've called our series You Decide Who Decides because it is an incredible and very practical guide that is available on Compass. You'll get a link to it tomorrow that has just been revised. It's published by the Australian Guardianship and Administrative Council, and it has lots of very helpful information. But straight up, I would like to ask you, Anita, what is an enduring power of attorney?
Thank you. And hello, everyone. I just like to acknowledge that a few friends are in the audience. I won't call you out by name, but so lovely to have you here. And thanks so much for inviting me. So an enduring power of attorney in Victoria is a document that we have. It's kind of like, I think about it in the sense of like an insurance policy. So it's something that we can do, that we can put in place, that we'll hopefully never need, but we do it just in case if we lose capacity to make our own decisions. Appointing someone as our enduring attorney for either personal or financial decisions under that document means that we control who makes decisions for us in the event that we don't, or the event that we can't. And the word enduring actually means that the power endures beyond our loss of capacity. So the idea is you're picking someone essentially to stand in your shoes and assume all the powers that you have to make your day-to-day decisions. So in Victoria, that includes financial as well as personal day-to-day decisions on our behalf if we can't make those decisions.
Great. And it might seem a simple question for some, but what is the difference between an enduring power of attorney, a will, an enduring guardian, and an advanced care directive?
Yeah,
Or,
it's a great question.
yeah, and in Victoria, I think there's another one that is specific to Victoria.
Yeah, so we have two sets of documents. So while we're alive, we have substitute decision-making documents. So that's the broad category that an enduring power of attorney sits under. So those are documents that apply while we're alive to govern what happens to our decisions if we lose capacity while we're still alive. So if, for example, we have a stroke, or we're in a coma, or we have a cognitive decline like a dementia diagnosis, for example. So I've just seen that there's some issues with volume. I'm not sure that there's anything we can do. I might just try and use, is this volume too loud if I'm talking like this? Is
Yes,
that
I think we've
okay?
got the volume up as loud as we
Yeah,
can.
yeah.
So, yeah.
So we have these substitute decision-making documents that are in place while we're alive. And so that includes the enduring power of attorney for both personal and financial decisions in the one document. And then a completely separate document, we have medical treatment decision-making in a separate, it's not called power of attorney anymore. And so those are the two main documents that can also be supported by some other supporting documents, including an advanced care directive. They all exist while we're alive. When we pass away, all of those documents cease to have any validity. So anyone you know who's using a power of attorney on behalf of someone who's died, please let them know to start doing that, because that's fraudulent use of that document. That document ceases to have effect when we die. And then that's where, if we have a will, that's when the will kicks in. So they're completely separate legislation and for separate purposes. It's just that we hear them talked about in the one breath usually, because when we go and get one of the documents done, we'll get all of them done because they're all under the umbrella of future planning.
Great. Looks like that, yes, we've got it as loud as we can. So I hope you are able to hear. We are sending out a recording tomorrow, which will be on our YouTube channel, and you will have the ability to adjust volume on that as well. Now, I'm going to jump to a question straight away. We're going to jump around with our conversation today, Anita. So
Right.
Jackie asks, where is the best place to keep your enduring power of attorney? So you've created it. Do you lock it away in a safe? Do you give it to your attorney and the people closest to you? Do you give it, do you register it somewhere? What is sort of best practice?
That's a really great question. And it's one without a straightforward answer, I'm afraid. It's one of those case by case, depends on your circumstances. There is no one central place in Victoria where everything must be stored. Our local public trustee, which is State Trustees, you might have heard of, they have a free register. So you can either register the original document with them so they keep it in safe storage, or you can advise them of where you're keeping it in safe storage yourself. But it is not a widely known register. So if you are going to use that register, please make sure the people who need to know where the documents are know that it's registered with State Trustees. Alternately, you can register it if you get it done privately with a lawyer. Most law firms will offer you safe storage of your document with them, or you might have safe storage options yourself. So that might be a waterproof, fireproof safe at home, or a bank safe deposit box, for example. What I would recommend in terms of best practice is with powers of attorney in Victoria, the original is the one that you sign, but you can create what we call certified copies. So there are certain people that can, I won't go into detail about who can witness, you can look that up, but there are certain people that can certify photocopies of your original document. So the lawyer who drafts the document for you should do this and actually provide you with not only the original, but also multiple certified copies, and they should be kept separate. So if there is a fire and the fireproofness isn't good enough and we do lose the original document, if the certified copy is kept somewhere else, then it's still usable. Also, that will mean some places will require you to lodge a certified copy, so it's handy to just have one ready to go, be able to lodge. So it's really person by person. In terms of keeping it with the attorney themselves, it's up to you. Ideally, we are only appointing people who we absolutely trust. So the guide, you decide who decides, has some great prompting questions for you to think about who you're appointing. But what the guide says and what we talk about in our talks is there is no monitoring system of who you appoint. So these are private appointments that you make. It's not like it's being done through the court. It's not being monitored by anyone. So you are absolutely entirely trusting that person to stand in your shoes and make decisions as if they're you. So technically, giving them the original document should be fine because you should be able to trust them to use it appropriately. So giving it to the attorney is technically an option. It just may not be what everyone chooses. You might like to have some kind of control that it's only accessed once it's actually needed.
Okay, great. Now, I'll get to attorneys in just a moment, but how do you go about creating an enduring power of attorney? Is there a form you can download? Should you seek independent financial and legal advice? What do you recommend to people?
So yes, it is a form that you can download. So what happened was we used to have a very simple version. So the enduring power of attorney used to be not even a full page of a document. So it was very simple, very straightforward form. And over the years in Victoria, it's been tweaked and updated continually. And the last update was just the last month or so, I think maybe back in September. There was another update to the way the form is actually created. And it's now the short version of the form that you can download, as in the least complicated version, is in the 20s of pages. I can't remember exactly how many pages long. So yes, you can access it. And so it's
You can access that
available.
actually on the Compass website. So
Yeah,
it's available on the Compass website.
Yes. So it's on the Compass website, or it's also, you can access it through the Office of the Public Advocate, have links, and the original is stored on the Department of Justice website. So you can download that. I would just ask you to think about this with caution, because what they've done is they've added so many different ways we can personalize the document to our own circumstances, which is brilliant because it means it's much more personal and gives us much more control. But what that does mean is it makes the document more complex, which means there's more risk of it being filled out incorrectly. So if you can manage to afford someone to draft it for you, who knows what they're doing, so someone who actually practices in this area as a lawyer, that would be the best practice, is to get someone who knows what they're doing to draft it. If you can't, maybe you can draft it yourself and still maybe pay a nominal fee to get someone to check it for you, because the cost of dealing with it, if it's done incorrectly and there's problems, the cost and the time and the burden to fix it up later is going to be so much more than the cost of just paying for it to get done properly now.
Yeah. Wonderful. Vanessa actually asked a question about this very thing, and I guess just to further ask you something, continuing on from Vanessa's question, you can put a lot of instructions or limitations. You can customize, can't you?
You can customize it. Yeah.
So
there's lots of examples actually in the guide of how people have customized. So I encourage people to look through the guide. It's brilliant, and they've got some examples, like things like, you can't sell my property unless you've got a certain number of independent valuations, things like that. You must consult with so-and-so before you do this.
Now, I guess one of the things we were talking earlier, Anita, and probably Vanessa and others will be interested, is whilst you can put limitations and instructions, they can sometimes have unforeseen circumstances, can't they? So
exactly.
And they could inhibit your attorneys to act in a way that would still be aligned with your best interests. So there are some risks associated with being too specific, aren't there?
There really is. And so when we're putting conditions or limitations in the document, that's why it's so important to get legal advice about how enforceable is that going to be and how practical is that going to be for your attorney. Because I don't know if anyone in the room has been an attorney, but being appointed an attorney, it's not a privilege. It's not an honorary title. It's actually a really big job. And for some people, it's a big burden. And so the more conditions or limitations we put on our attorneys, the harder we make their job. And if we put a condition or a limitation in and then unforeseen circumstances come up that we haven't predicted, that are in conflict with the conditions, our attorney is going to have to go off to VCAT and go through the whole rigmarole of getting the document edited or getting new orders made. So absolutely, if you are insisting on putting some conditional limitations, you're entitled to do that, but please get some advice before you sign it off.
Wonderful. We've got a question here from Sharon. How do you track effectively if someone changes their documents, an old one is presented, used following the person losing capacity? So the principal's lost capacity. There is an old and a new one. So one has been revoked, and there's a new one out. But how does a bank or a aged care facility or know that they're looking at the latest version?
So really, really good question. And this is one of the conundrums we have by not having been able to solve the conundrum of a central registry. We therefore have this conundrum of what do we do with multiple versions. So the first thing I would say is you can't update and change your power of attorney unless you've got capacity.
Yeah.
So when you're updating your power of attorney, making a new one, you should make your best efforts to destroy the old ones or mark that they're revoked. The act of filling out the new one, usually within the document itself, it says I revoke all previous powers of attorney made by me. So the document itself is a revocation. But if you've got capacity to make a new one, you've arguably got capacity to go back and let all of the facilities know where you might have given them copies to update it. So it's the responsibility is on the principal there, the person making
while they have capacity.
While they have capacity is to make sure that you get rid of or mark as revoked and let all the services know. If somebody is using a document they know is out of date, then I would be getting legal advice about that straight away, because that could be a matter that could go to the tribunal.
Wonderful. Okay, thank you. That's very helpful. Now we're going to get on to attorneys and capacity and other topics, but we've got a great question here from Jane. I have assisted older people who have absolutely trusted their adult children, who have subsequently misused the EPOA to swindle their parents, the principals, out of their home and finances, etc. Now, I'll just interject there that there was a national elder abuse prevalence study released in 2020, which was the first national study which indicated that abuse is experienced by older Australians up to about 1 in 6 every year, and financial and psychological abuse were right up there as the most prevalent. And unfortunately, adult children can be often the perpetrators of abuse. So it's not an uncommon scenario. What would be best practice regarding who and how many EPOAs a person should appoint? And also, I think a follow-on question here, if someone close to the principal suspects abuse is taking place, what can they do?
So hi, Jane. Good to, again, to have friends in the audience. So unfortunately, this is a live risk. And so I too have my background, I should have said from the start. So I work for Eastern Community Legal Centre. We are the local free legal service for the whole of the Eastern region of Melbourne. And I'm privileged to work in our community engagement team, which is the fun team. And so I get to do fun stuff like this. But my background was as an estate planning lawyer a long time ago. And then subsequent to that, I was an elder abuse lawyer for a few years myself. And so I had many clients who had capacity still, and they'd appointed their children as attorneys, and the children had misused the powers of attorney to perpetrate financial elder abuse. So unfortunately, the only way to absolutely guard against that happening is to leave it up to the tribunal. But even then, someone told me the other day that their perception was that the tribunal had appointed someone who wasn't acting in accordance with the wishes of the principal. So so Jane's question is, what is the best practice about who and how many how many attorneys under a power of attorney should you appoint? So
can you have more than one in Victoria?
You can have more than one. You can have multiple acting at one time. So there's different ways you can have them acting. So you can have them acting jointly, which means they all have to make decisions as a unit. So
does that provide helpful oversight?
Yes, it can provide helpful oversight, but it can be very cumbersome. So if we think about the realities of that and the realities of modern life and the fact that our attorneys will all have their own lives to manage as well. So think about juggling that and thinking about how practical is it going to be to force them to make every decision together. If you've got more than 3, you can have a different rule where they have to decide by majority. If we're doing this because we don't trust the attorneys, that should be a great big red flag, and we shouldn't be appointing them at all, because go back to my previous point that this isn't monitored. So it is possible for our attorneys to misuse the documents without it being caught or picked up by the services or people around us. And particularly if we've lost capacity, it can be very challenging. The other option is you can have multiple attorneys appointed as joint and several. So what that means is they can make decisions together, but they can do it separately. So that might be more practical, and also sharing the load amongst multiple people. And that can be as many as you choose. Again, if you're looking at making that complicated, please get some legal advice about the practicalities of that. And then also think about, do you want backups? Do you want alternatives? The other option that's there is not appointing someone in our lives at all. So Jane's question is, how could we think about appointing someone who's not going to use elder abuse against us?
Well.
Yeah,
who are candidates potentially?
So there are trustee companies. So State Trustees is the government-owned agency, but there are private trustee organisations as well, and some private lawyers and some accountants will also do this work. The payoff for that is literally that there will be a cost associated with those services, but that may be where someone is concerned in terms of not having someone in their life that they can absolutely blindly trust to stand in their shoes without being monitored and making the decisions that they would have wanted. And this is key too. We shifted the focus has gone from being acting in our best interests to actually acting in accordance with our will and preferences. So the responsibility isn't just a parental sort of best interest model, but more actually, what would we as an individual have wanted? So for example, once had a client who had 4 children, only one of them understood that the client wanted to live at home for as long as possible. The other 3 were ready to move the older person into aged care, and the older person had capacity and understood all the risks. And so they actually didn't give the power to the other 3 that didn't understand that, even though it might have been in their so-called best interest, they might have had less risk of falling over or whatever it might be. They wanted to take that risk anyway for the benefit of staying at home. So they appointed the one child that did follow that wish.
Yeah. So in Victoria, I think the key takeaways here is you can appoint more than one attorney. You can have them make decisions together or independently.
Yep.
Now, who makes a good attorney?
Yeah, it's a really good question.
Someone obviously that knows you very well, and someone that you trust. But are there other good characteristics in an attorney, specifically for financial decisions?
Yes, so I think the trust thing is the number one first bar. If we don't pass the trust bar, let's not even bother doing the other assessments of the person.
Better not to appoint someone.
Better not to appoint someone at all, because what will happen is if we don't appoint someone at all, there's no one in our lives who, not even our spouses, not even our parents once we're adults, no one can automatically make our financial decisions and possibly our personal decisions as well automatically. There is a backup for medical, and next of kin can make our medical treatment decisions. But for financial, there's no one who automatically makes those decisions for us. So if we don't appoint someone because we don't have someone that we trust, the Victorian Civil and Administrative Tribunal have a special list that's supposed to be easy to use. You don't have to have a lawyer to be represented, and you can go to the tribunal and say, this person's lost capacity, we need a decision maker to be appointed. And the tribunal can look at the situation and say, is there someone in that person's life? They don't have to be related to us. They can be a family member, or they can be a friend, or they can be a colleague who's willing to take that on, who's got capacity, or do we go an independent person like a trustee agency or a professional? So once we've established if someone is trustworthy, we then want to think about, have they got capacity to do this work? Because like I said, it's actually a pretty big job. So it depends. The person might not have very much that they need managed, so it might be okay. But for someone who's perhaps had a diagnosis, for example, of a cognitive decline, the amount of work that might need to happen could be quite extensive. So you could be asking quite a lot of your attorney. It can be kind of like a part-time carer role, getting all of that paperwork done, all of that. So having that in mind is really important. And then thinking about someone who is literate with computer systems, online systems, forms. I've got an aged care form that someone's got to fill out to be their, I can't even remember the word, to be their nominated registered support person. The form is unbelievably complex. And as a lawyer, I'm finding it hard to understand when they're asking questions, what they're actually asking for in that form. So you want someone who's able to manage admin, things like that, really with ease. You want someone who's going to be around. So someone who's got a job that they travel with internationally, maybe not so helpful. You want to have somebody who's good at making decisions in a crisis, someone who's maybe good at managing family conflict. They can be really useful as well. So just really imagine the scenario yourself and think about what, in your personal circumstances, what do you think your attorney should be good at to step in your shoes and basically be you for the purposes of these decisions.
Thank you. That's very helpful. Now, we will get to supported decision making. I really want to have a good conversation about that.
Okay, great.
Definitely ethical and honest. Yes, I think they're very good characteristics.
Ethical and honest. Excellent. Yes.
In an attorney.
Yes.
So there is a question here that I wanted to go to, which is Sam asks, what is the process to get, I'm going to say, an enduring power of attorney if you don't have capacity? Well, you can't, can you? You can't make one.
So you can only make a power of attorney if you pass the test for making a power of attorney. So decision-making capacity is a really complex thing. I do a whole presentation about it, so I'll try and sum it up really quickly now.
Who decides if you have capacity?
So it's actually a legal test.
Right.
People assume that your capacity to make decisions is a medical test. Medical evidence is very good at supporting that, but actually it's a legal test. So in the power of attorney legislation, there's a 4-stage test. Yeah. So we have to pass that test. If we do our power of attorney with a lawyer, their best practice will be that they'll actually do that test on us and ask us those questions.
What are those 4 things?
I knew you were going to ask me that.
Is it that you understand the question?
So okay, so I'm going to forget it, which is hilarious given the context of the conversation. So you need to be able to understand the nature of the document. You need to be able to communicate your circumstances. You need to be able to understand and weigh up your choices, and you need to be able to communicate them back. So it doesn't have to be
verbally, does it?
It doesn't have to be verbal, no. It can be with communication aids.
Yep.
So we can have capacity under lots of really extreme circumstances. We can still have and as long as we still have the ability to make our own decisions, then we, regardless of whether we can verbalize or we write it or other communication aids. And so we can only make the document ourselves if we pass that test. So we might pass that test for one document. So, for example, we might pass a test to understand our medical decisions for the medical treatment document. We might not pass it for the financial. So it's possible to have capacity for some things and not others. So it's quite complex. So if there's any question or any concern about someone's capacity, making sure they get the document drafted by someone who knows what they're doing and having supporting medical evidence can be really good practice. To go back to the question.
Yeah, what is the process to get a power of attorney if you don't have capacity?
If you don't have capacity, so that's where the tribunal steps in. So if we haven't done the document already, then all is not lost. The tribunal, so Victorian Civil and Administrative Tribunal, VCAT, has the power to make orders for us that are equivalent to the powers that you get under an enduring power of attorney. The difference being you're appointed as an administrator instead of a financial attorney, or a guardian instead of a personal attorney. And the other difference is you're monitored by the tribunal as well, which is also an added benefit. I'm so sorry.
So if you've lost capacity, it's someone else who's going to have to approach VCAT, aren't they, on your behalf? Yeah.
Yep. So usually it's a family member, but it could also be someone in our lives, like a social worker at hospital or the facility manager in a residential care scenario. So anyone who is aware of our scenario can lodge that application with the tribunal, and then the tribunal assesses all the evidence, and the tribunal makes an independent decision on who should be our decision maker.
Right. Now, we've got quite a few questions, so I'm going to try to go to a few of them. A good question here from Maddie. Can a pensioner, a person on low income, get free help through the Eastern Community Legal Centre, COTA, OPAN, or other agencies tasked with assisting folks?
Maddie, I'm so sorry. Unfortunately, there aren't any services that are funded to draft these documents for free. I think there's definite need for a free legal service that just does powers of attorney, substitute decision-making documents and wills because of that exact scenario. So the free option is for someone to download the document and complete it themselves. But if they are wanting to make sure that it's done properly, perhaps a lesser cost will be if a lawyer is prepared to check it, a reduced fee if you've actually completed the form yourself. But unfortunately, there's no service that drafts these documents in and of themselves. Some services might draft them if they're supporting someone through an elder abuse situation. That might be part of the legal work they do in response to the elder abuse, but they won't just in and of themselves draft those documents for free. I'm very sorry.
Okay. We've got a question here from Vanessa. Client has a joint power of attorney, with children not able to act severally. This works quite well, except residential aged care will only contact one person, irregardless of the POA stating joint. This is okay for basic care, but for major decisions, this poses a real challenge, doesn't it?
Yes, so I would refer Vanessa to the in-house legal at the aged care facility, because I'm going to be careful that I can't give anyone legal advice here today. We're here to give information only. But I've been encouraging Vanessa to speak with the internal, that most aged care facilities will have some kind of internal compliance department that might have their own in-house lawyers, or they might engage external lawyers, but to actually take that up with the aged care facility.
Right. We've got a good question here from Maddie, which I've got a follow-up one already. If you appoint an external independent agent, such as a lawyer or an accountant, to be your attorney, what happens, when your attorney retires?
Yeah, or dies before you.
Or dies before you, or that practice no longer exists.
Yeah,
Do they
goes
have
under.
responsibility to handle the transfer of that enduring power of attorney? What can happen?
So ideally, particularly for appointing a lawyer, and the lawyer is one drafting the document, the lawyer will anticipate all of that. So if it's a really, really big firm that's been around forever, they might have some wording in there to say the firm, or whatever the firm becomes known as down the track. So there might be some sort of succession planning built into the appointment, into the wording. And it wouldn't be necessarily a person maybe specifically who's appointed. So for example, when you appoint state trustees as to be your attorney, you're not appointing Melissa at state trustees, you're appointing state trustees, and whoever is allocated to your file does the work, but it's not one individual person. So if that person who's got your case moves on, then there's someone else. So presumably when a lawyer is, and I haven't seen it done, but I'm presuming with a private lawyer does it, they will build the succession planning in. If they're a sole practitioner, then they should have a backup. So in our documents, we can always put, if our attorney, whoever that is, isn't able to act for whatever reason, we can have as many backups as we want. Right. So you can have the multiple alternatives in there.
That's my follow-up question, this idea of having substitute. I know a lot of people choose their husbands, their wives, their partners, to be their attorney. You know, one of the challenges there, I'm the same, is that person is often close to or the same age, if not older. And they could be also...
It could be in the same car accident that we're in.
Yes, they could experience cognitive decline in the same kind of ratios. And then I know often people have as a backup, or their adult children, which is obviously a generation lower. I know I've got a backup of my niece who's only 23, very responsible 23-year-old.
Wow.
But there are advantages there, aren't there, in having somebody, because this document could be around for a very long time.
Yeah, so somebody asked me that recently, like, when do these documents expire? They don't. So the word enduring, as I mentioned earlier, means the document endures through your loss of capacity. So they only become invalid if they've been overridden by us while we have capacity, or the tribunal's cancelled it, or we die. So there's no expiration date built into these documents. So it's quite possible you could have it for 50 years. And even if the law changes, as long as the document's made in accordance with the law at the time correctly, then usually future legal changes to the law won't invalidate the old version of the document. So it's very very possible in that scenario we have the document for 50 years that someone will predecease us, or we'll have moved into state, or we'll have fallen out, or whatever it might be. So regularly checking it to make sure it's up to date is good. But if you've lost capacity by that point, then putting in somebody who's an appropriate backup is really important. And while we're talking about who we appoint, it's important to know you can't just sneak attack appoint anyone like you used to be able to. You must check with your attorneys before you appoint them that they're actually happy to be appointed.
But they have to agree.
They have to agree, and they, in fact, have to sign something to say in front of a witness that they agree to be your attorney and to act in accordance with the rules. Right. So you can't just surprise somebody with this burden. You must check with them first, and they must sign their acceptance. Even if they sign their acceptance, they are allowed to change their mind down the track. And if they refuse to act, then that's when your backups can come in.
Right. Two quick questions. One is how often, often people create a will, or they'll create an enduring power of attorney, and, it sits there and doesn't need, I've got mine already done, but I might have capacity or never lose capacity.
Yeah.
Very long time.
Hopefully.
So how often should you be reviewing these documents?
Ideally, you'd look at it every year.
Right.
So, the old expression, nothing's certain in life except for death and taxes. So we say maybe you associate death with taxes. You think about at tax time, that's my chance to get all my affairs in order every time I do tax. For once we retire, though, that sort of loses relevance. But if there can be some kind of annual prompt, obviously not your birthday, that's very unfun. But if there's, if it's end of financial year, for example, whatever it is, it doesn't mean updating it. You may never need to update your documents once they're done. They may be fine for the rest of your life. All it means is just reading through and just checking and making sure they still apply, and that there's nothing in it that's going to make it more complex, because you're wanting things to be as simple as possible for your attorney so they can look after you.
Great. Now, if you do want to change it, obviously that means revoking. How do you go about that? Is there a form?
So there is a form, and the rules in Victoria just changed to try and make it easier to revoke documents. But the most common way that people will revoke a document is by making a new one. So within the document itself, it will say something along the lines of, I hereby revoke all previous powers of attorney made by me. But as I said before, if you do that, please make sure you destroy or write revoked on any versions of on any older versions, and make it clear that they've been revoked.
Now, I just wanted at this point to mention that there are some really helpful articles on compass.info in our Enduring Powers of Attorney section. There's a great short video on capacity and a great article called Having Capacity. There are also articles on how to choose an attorney, how to be a good attorney, because it doesn't come with training, and an introduction to Enduring Powers of Attorney, and a section specifically for Victoria on how to create, revoke, all the forms, and helpful videos as well to watch. So I just wanted to jump now to a follow-up comment from Jane. Jane says, the very unfortunate reality is that money often changes even trustworthy people, which often results in decisions being made that don't align with the principal's wishes. Now, I came across a comment recently from somebody I know who, is raising a few children. Both adult parents are quite old, have separated, live in multi-million-dollar houses, both of them, that are way too big for both of them. And I could sense a bit of resentment from this person, thinking, hurry up, or can't you make some decisions because I'm struggling. We're raising 3 kids, school fees are expensive, life is expensive. There are pressures there, aren't there? I know there's a common term called inheritance impatience. But it's a reality, isn't it? Jane is right. There are those sort of pressures, and things do change.
Absolutely, Jane's right. My starting point would be, from a human rights perspective, unless you've got someone who's dependent on you because they're financially dependent on you because they have certain circumstances that mean you're providing for them because of a disability or an addiction or whatever it might be, unless the person's actually financially dependent on you, you have no obligation to provide for any adult family members in your life. And so, in fact, the law got tightened up in Victoria 10 years ago to make that really clear, that independent children really shouldn't have a claim on things that are yours. And there's another thing, the opposite to inheritance impatience is going skiing, which is spending the kid's inheritance, which is something I personally advocate for.
Your money.
Your money, you've earned it. And yes, I acknowledge the cost of living crisis and particularly housing, and we're a very different financial climate at the moment. But that doesn't change the fact that unless you are financially responsible for somebody, you actually don't have an obligation. That's not what happens in real life, exactly as Jane's observing with her astute observations. But with money changing people, yes, that can be where we might have in our document, we might have some requests. So for example, I think it might be in the guide where they say, I will appoint a family member, but the family member must get the financials audited by an accountant every 6 months, every 12 months, or whatever it might be. So there's still ways that we can put in some accountability into the document if you choose to do so.
Now we're actually having, we're really racing through our conversation, so I will jump to a few questions quickly. But I did want to, before I do that, just talk about another term that I have started to hear a bit more commonly, which is inheritance maintenance, where adult children who have become attorneys for their parents are actually sort of underspending to maintain the inheritance, which is, I guess, could manifest as not providing adequate care, healthcare, not keeping things maintained, neglect. I guess. Neglect.
So that is an active misuse of the power of attorney and a breach of the attorney's responsibilities. So when you are appointed as an attorney, it's really clear, and this is across all jurisdictions, you must not act in any way in a conflict of interest between your own interest and the principal, the person who's given you the powers, interests. And so anytime you do that, it's like trying to preserve your future inheritance, which is not yours. It's not yours until the person has died and you actually inherit it. No one's entitled to that unless, like I said, they're financially dependent. So I've lost my train of thought. Let's go backwards. So that would be a misuse of the power of attorney, and that's the kind of thing we could take to the tribunal. So if the principal has lost capacity and they can't revoke the person's power themselves, then the matter can be taken to the tribunal. Again, the tribunal has standing to actually investigate misuse of powers of attorney and also to have consequences against the person misusing the power.
Yeah. Okay, great. We've got a question here from Sharon. Often at the time of agreeing to be the power of attorney, there is limited comprehension of the longer journey of the person you'll be supporting. That's, I think, a very valid comment. The complexity once aging, comorbidity, and possible conflict can be very overwhelming for even the most capable power of attorney. So I guess I mentioned that comment from Sharon because, she is right. I've, appointed my 23-year-old niece who probably hasn't fully understood that one day, if I've lost cognitive ability, that there are maybe a lot of decisions that need to be made. I mean, I guess this is where I think some of the articles on Compass can be very helpful. How to choose attorney, how to be an attorney. I think actually talking to attorneys, isn't it, about what the role involves so that they are as well prepared as possible. Are there any other guides that you?
Yes, so there's a guide with the Office of Public Advocate. I'm going to fish around for and see if I can grab while we're talking, which is really comprehensive. So when you appoint someone as your attorney, like I said, they have to accept their appointment. So that's really good. They have to actually accept that they've been appointed. but it's a short statement, so it does clarify some of what you actually need to meet as an attorney, but there are other guides like this one from the Office of the Public Advocate, for example. So you could provide, when you're appointing someone, you could provide them with all this information. You could talk to them about your circumstances. You can record a story to go with your power of attorney. So sometimes people might do a document, they might call it a memorandum of wishes. So you can try and ease the burden on your attorney by recording as much as possible, by involving them in things while you've still got capacity as much as possible, so that they are as much aware of what your wishes would have been and also what your affairs are and what they're actually getting themselves into. And then also, Sharon, the person might burn out. They might agree to do all of those things and then they might burn out. So they could be backups that are built into the document if that happens, so that someone else can step in. A really good point.
A really good point. A follow-on question from Sharon, and then I'll go to Brenda, is the concept of supported decision making. And I know when I was appointing my attorneys, I sat them down, I made them watch videos, I printed out PDFs that I downloaded from
Best
companies
practice.
and gave them to them to read, in particular about supported decision making, because the document itself is called an enduring power of attorney. So implicit in there is this idea that you do have a lot of power, but actually increasingly you do have to be always making the decision, don't you, of the principle. You're not making decisions based on your own values or what
Or
you think
best interest.
or best
Yeah.
interest, but
Yep.
what you know the principal would want the money to be spent on. So
Yep.
can you expand a little bit about supported decision making, and what it means? Because, I mean, the idea, even with someone with dementia, as I understand it, correct me if I'm wrong, is even with people with reduced capacity to make decisions, you still have to support them, don't you?
Absolutely.
Yeah, you can't be sort of substituting. That term substitute decision maker is sort of going out of the law and this idea of will and preference.
Exactly. So the law specifically says that we must involve the principal as much as possible.
Mhm.
So there will be obvious times when we cannot. So if the person is in a coma, for example, that is very black and white.
Yeah.
But other than that, involving the person in the decision making as much as possible is exactly what we're meant to do. So someone might activate the power and then might tick the immediate activation box. So we might be able to support the person in making their decisions while they've still got capacity as their attorney, because it gives us power to do the running around and accessing information. But we cannot take away the decision making of that person until they've lost that specific capacity for that specific decision.
Yeah.
So, and even if they've lost capacity, like you said, sometimes it's still possible to suss out from them what their wishes would be if you don't already know.
Brenda asks, in the powers of attorney do vary in Australia, state by state.
Mm-hmm.
So in New South Wales, for instance, an enduring power of attorney is only for financial decisions.
Yep.
In the Northern Territory, it's called an advanced personal plan. You don't appoint attorneys, you appoint decision makers. So with the fact that the country is, I think it's about 50-50, but uses different language for various things. If you've created, say you created your enduring power of attorney in Victoria, but then you subsequently move to another territory or the other way round, should you make a new enduring power of attorney in the state that you now reside?
Yeah, I think it's very worthwhile getting advice.
Mm-hmm.
If you are temporarily living interstate and all your assets and affairs are back in Victoria, that might not change anything. But if you're relocating assets, it would be good to get legal advice about where should your decision-making documents sit. So which jurisdiction should they be in? So some states and territories have reciprocal recognition rules,
So
which
even if you
means,
lose capacity, they should be still respected.
but I can't comment on the exact. For example, I'm pretty confident we have that with New South Wales, but so for example, if we moved to New South Wales and we lost capacity before we got around to making a document there, it might be possible that the agencies over there will recognise a Victorian document and vice versa, but I can't say that for sure. So if you're going interstate, please check and make sure that you've got the best version of the document for your circumstances.
Yeah, yeah. So I did want to go to another question here, which was a comment from Kate. I think is a really interesting one about certifying copies. Kate says that as a JP who has witnessed many enduring powers of attorney, she suggests reminding people that these documents need to be certified as copies in a particular way on each page.
Yeah.
So please find a GP. I've seen others where the police member had just stamped the first page in a copy, and that won't be valid. So
I'll add to that,
you know,
Kate. I also saw a doctor witness their own signature once. They did their signature and then witness their own signature. So you can't just trust that everybody knows what they're doing. Yeah. So there's registers to look up where you find JPs. And as I said, if you get your original document done with a lawyer, they should actually do that for you, and they will understand that every page needs to be certified. It's not just the front page. So it's one of the sort of safety mechanisms, I guess, of getting it done properly, is that you'll also get the certified copies made properly as well.
We've got a question here from Lauren. Lauren works in an area with gambling harm. I see elder abuse when a family member, carer, attorney with gambling issues has accessed the bank details and IT. Lauren would suggest people register with BetStop Lifetime and contact the banks to put in gambling lifetime blocks, not just the block that can be toggled on and off in the app. Is there anything else you suggest? Well, I guess before you answer that, I guess one of the things is in appointing attorneys, you do want to potentially think about if someone does have gambling issues or addiction or substance issues, that might be a bit of a red flag to being.
Or any other kind of financial mismanagement in their own lives. Yeah.
But what can you do? Because, habits change and people's behaviors can change. I suggest, I'm thinking the things that Lauren is suggesting are probably quite practical.
Yeah. I think perhaps we don't have a monitoring system, and this is not a question I've been asked before, so let me just sort of think out loud if that's okay, but perhaps creating your own monitoring system within your own networks. So letting people know who you've appointed as your attorney, so that if you lose capacity, that people are aware of the people who are around you who will have that power. And if they observe that there's behaviours of concern, that they can reach out to the tribunal or to the Office of the Public Advocate helpline and get some information and advice about what to do.
Now, Brenda's put another follow-up question here. And one, I think, Brenda, I would recommend seeking independent advice. There's lots of information on Compass. But as we've been talking about the fact that enduring powers of attorney documents are not harmonised across Australia, I do think the Attorneys General have in the last few years met, and there is reciprocal arrangements in most states. I can't be absolutely sure there. So do check the information on the Compass website. But normally if there are reciprocal arrangements in place, it doesn't matter where you are. Your documents will and should be respected. But do seek independent advice on that one. Now, I just wanted to ask, we're getting very close to the end of time. I've got a few more questions. One is, what happens if you don't have an enduring power of attorney? You just never make one.
Yep. So hopefully you'll never need it. And so if we go through the rest of our lives without losing capacity, and hopefully that's what happens for all of us here today, we go through the rest of our lives, because, I heard from a geriatrician recently that loss of capacity is not a natural part of aging. So that's just something that happens to some of us as we age. It is not a natural part of aging. So hopefully we all age with full capacity, and we reach the end of our lives. We never need a power of attorney document while we're alive. if we do lose capacity, then that's when someone can make the application to the Victorian Civil and Administrative Tribunal for them to assess our situation and see. And they will only appoint someone as an absolute last resort. So they will treat our situation with the most, with highlighting our human rights as the absolute priority. And so they will say, we can only appoint a decision maker for someone if they've lost capacity and they have decisions that need to be made, and appointing someone will actually promote their personal and their personal well-being. So there's very much a human rights focus from the tribunal that they won't interfere in our lives unless we absolutely need it, and it will benefit our well-being.
Mm-hmm. Now, we've got a question here from Jenny, which I'm going to sort of summarize. And Jenny has put a question to us that is a particular scenario, but say you've got an attorney who has behaved badly, let's just say generally, and that person is also the executor of your will. And so I'm not sure that we can answer this question.
That one's very specific, Jenny. So what I would say is the tribunal has powers to hold attorneys to account if they misuse or abuse their powers under a power of attorney. So that's while the principle is alive, that we can go to the tribunal and work that through. In terms of what impact that would have on the will, I'm not in a position to get into that level of detail today. Yeah. So encourage you to get some legal advice, but just know that there is capacity for the tribunal to examine the misuse and abuse of powers.
Yeah. Now, there are some great articles, as I've mentioned, on Compass. There is one on misuse and abuse. Also, really helpful articles for particular parts of our community. If you are from a culturally and linguistically diverse community, the LGBTQI plus community, First Nations community, there's lots of information there about the specific things that you might want to be thinking about. We've got a question here from Maddie. Say you've had your enduring power of attorney drafted by a third party, a lawyer. Look, it doesn't cost anything for you to review it annually. It just means reading through it.
Yeah.
If you want to change anything, and I suppose that's where you might be experiencing a fee from your lawyer.
Exactly. So yeah, so reviewing it is with you, not with the lawyer. So reviewing it is just getting the document out. You might have a copy of it at home if they've kept the original, and just reading it through and making sure it's still all relevant to your life. If you want to go back and ask them to make any changes, since they've already got the document, it's not like in the old days when they had to get a new piece of parchment out and write it all out from scratch. They just need to edit a form. So I wonder if they might have a discount for just updating rather than doing it from scratch. That might be worth asking.
Yeah. Now we've had, I'm going to take one more question and then we're going to wrap it up. As I said, the recording will be sent out tomorrow. Look, I also encourage people to subscribe to the Compass monthly newsletter where you'll be informed of things to do with enduring powers of attorney. Comment that has been mentioned at last year's Elder Abuse Conference in Adelaide. There was talk about the need for a national register. So these conversations are taking place with the Attorneys General, and so you'd be alerted to any changes there. And there's a great news section on Compass, which does have updates on various topics. Rosie asks, and this is the last question, what is the first step to have a situation abuse raised in order to protect an older person from their own children? I think we have answered this one, isn't it? It's basically raising it with VCAT.
So first of all, hi, Rosie. Good to hear from you. So if the person has capacity, so if the person we suspect is experiencing abuse has capacity, then we please encourage them to contact either Eastern Community Legal Centre if they're in the Eastern region. We have a specialist elder abuse program, or Seniors Rights Victoria for anywhere else. So the person can access legal help themselves. If the person has lost capacity, calling the Office of the Public Advocate's helpline might be a good starting point to have some guidance on where to go from there. But you can also talk to your local legal centre and get referrals to the appropriate services as well. So I encourage you to reach out to a legal service to be able to access some support for that as well.
Wonderful. Thank you. It has been a terrific conversation. Thank you to everybody who has put a question forward. And also thank you very much, Anita, for all of your help and skill and advice. It's been very interesting, and I hope that you have walked away with knowing a little bit more about enduring powers of attorney in Victoria and how they work. Now, if you do want to follow up on anything, we'll be sending you out an email. Compass is a project of EAAA, Elder Abuse Action Australia. And that's a great organization that is trying to raise awareness and raise initiatives to help reduce and respond to elder abuse in all its forms. If you are experiencing abuse or you are aware of somebody who is experiencing elder abuse, there are lots of service providers on Compass and a filter system. You can choose elder abuse specialists, or there's the National Elder Abuse Helpline on 1800 353 374. Thank you very much, Anita. Have a lovely afternoon, everybody, and thank you again.
Thank you so much.